have the children spend half the time with that parent. And obviously there's some extreme examples here where you would want to have some kind of an approximation, perhaps. But what we're pointing out is with or without an approximation rule. Just move that to the side. These psychologists are saying there's a minimum amount of time that a non-custodial parent needs to be available to the kids. So, approximation rule or not, we still need a minimum guideline to our judges.
Now, we've been talking about people divorced or getting divorced or potentially thinking about divorce, but there's also the other side of the coin dealing with people who are not married and have children and are still facing some problems. And just doing some of the research on what you guys have been involved with, do you think that mandatory parenting agreements is a good idea? Are they popular? What has been your experience?
Well, we are looking at that. We're being asked for our opinion on that, actually. It is popular. We've noticed states over the U.S. who watch the news and other children's rights councils and other advocacy groups in other states contact us and fill us in. And there are this move toward mandatory parenting agreements. I think it comes down to the details on it. There's definitely merit in it, and I particularly, in my view, when you're looking at these unmarried parents, we have somewhere between 60 to 70,000 births in Illinois each year to unmarried parents. And the breakup rate of unmarried parents is quite a bit higher than for married parents. This has been validated in various studies, or substantiated in those studies. So when those parents break up, there isn't nearly the immediate engagement in the legal process that there would be in a divorce. And so without putting in some kind of a mechanism that would trigger the need to write a parenting agreement, the non-custodial parents in those cases, which in Illinois case law is almost always going to be the father of the unmarried parents, they don't really have any thing on paper to provide protection for their parenting time with that child. They could be locked out entirely.
Right, they could be the biological father, but they still don't have any legal rights established.
They basically don't have a leg to stand on without a visitation schedule written into a parenting agreement and approved by the court. So we definitely need something that would create in the minds of every parent out there, whether it be the mother or the father, something that would be a judicial or a legal standard that would say, look, you're going to have to file this, so you better get used to the idea that you need to start writing this down on a piece of paper.
Right. And it's important because we want to look at what is in the best interest of the child.
Right. And Dan, that's another thing that, we talked about in our hearings is that, and I mentioned it in testimony, that what we do in the courtrooms matters a great deal more than the 2 or 3% of cases that go to court. It sends a signal for all of society as to what is expected. And without things like that being part of the rule of law, then that sends a signal that it's not important. So that's another reason to look at implementing those.
Well, there are certain factors that the judge has to take into consideration when determining an award of custody or visitation and setting up a parenting plan. So I believe that the judges already have the tools that they need to help implement what you're actually been trying to testify to.
Absolutely. In fact, we've been told by almost all these things actually already occur in court. It's a matter of degree, it's a matter of frequency, and it's a matter of is it to the right level? And we've been advised by attorneys talking to us as board members that for our primary thing, which is the parenting time share of school overnights and half of all summers, that the research we can point to substantiates needs to be in there as a standard in order to protect the children. We've been told that we do not need a change in Illinois state law to do that. You look at the Illinois state law passed in 1977, the Illinois Marriage and Dissolution of Marriage Act, IMDA, states right in it. We believe that the maximum involvement of both parents is what's in the best interest of the child. And I throw that up on a screen at some of my public presentations, and then I throw up on a screen the written substantiation we have that there's this de facto minimum visitation guideline of every other weekend and 4 hours on Wednesdays, and you can hear the crowd sort of, almost starting to chuckle, thinking, what? That's maximum involvement. But that's their interpretation. So really, judges could interpret the existing law differently, and maybe that has to come from the Supreme Court down. That's what's happened in other states where the Supreme Court stepped into it and said, okay, we really need to have a guideline here that makes sense and is in line with psychologists' recommendations.
What has been the feedback that you have received regarding not just your testimony, but what you've been trying to help implement and educate fathers?
It's been very positive. I'm glad you asked that question because I talk to custodial mothers up and down the state whenever chance I get. I talk to dozens of them at length about their own personal cases. I talk to married parents, soccer moms, all kinds of people. I talk to judges and attorneys, and so does the rest of our board and our activist volunteers. And across the board, the majority are very supportive. I mean, they truly agree with us that this makes sense. That it does not make sense that given the level of father involvement that's typically true today in a married or a nuclear household, that suddenly that person has got to feel at risk of not seeing their children after 8 o'clock at night, for overnight or in the mornings for the rest of their lives, except every other weekend during the school year. It just doesn't make sense. So the reaction we're getting from our proposition is that it's very, very reasonable. It makes sense. Really, the only resistance that we come across is from judges who say, well, I don't like the idea of my judicial discretion being reduced. Well, our response back, and I testified to this, is, you know what, there's already a standard out there that's being practiced all the time. That's the problem. It's a cookie cutter, one-size-fits-all visitation schedule from one end of our state to the other end, but it's the wrong size. And if you're going to have one, if you're going to have a visitation schedule that's a cookie-cutter approach, at least make it the size that the psychologists and other people are saying it has to be.
One thing that I wanted to briefly talk about before we run out of time is something that was suggested about putting a possible positive parenting clause into an agreement.
A positive parent, well, we do have already what we call the friendly parent clause, is sort of known as that in Illinois, which is one of the 9 factors that a judge has to take into account in awarding custody. It looks at is the willingness and the ability of the parent to be cooperative and supportive of the other parent. It was interesting in the hearings. There's a Dr. Alan Ravitz and also another president of the Family Institute at Northwestern University, Dr. Pinsloff, and both of them were saying how important it is this attitude of the parents toward each other and supportiveness toward the other parent's role. And I think we're all struggling with that. Like how could we enhance that attitude of supportiveness toward the other parent after divorce, where you can get the divorce emotions out of the way and focus on what's best for the kids.
Right.
And one of the things that is bounced around is mandatory counseling. Now, in Illinois, we've been told it's generally not too difficult to get a judge to order a couple to counseling. So perhaps, I don't know the degree of, that would really be necessary or would improve things, but that mandatory counseling is being talked about in a lot of other states, and people are looking at that. It'd have to be in-depth. It'd have to be more than just a few sessions to try to get through to these parents. Look at, you need really to take this is the most critical thing for your child, is your attitude toward the other parent and their role in your child's life as a parent. I want to mention the Supreme Court in Illinois did hand down rules of court a couple years back, in 2006, when implemented in 2007, that required co-parenting classes, 3 one-hour co-parenting classes for all parents with visitation or custody issues. And I think that was helpful, but it's a pretty small step for these high conflict cases.
Right, I agree. Unfortunately, we have run out of time, but again, I know you've been on our show before. I appreciate you taking time out of your busy schedule. And as always, we appreciate all the work that you do, and I look forward to having you on again. And for the people who are tuning in, you can find this podcast on DadsDivorce.com, as well as other issues that are coming up in the legal field. And we also have Ask a Lawyer, which you can click on that icon, submit a question either based upon this podcast or prior ones, or something that's happening to you. You can submit your question, and we'll try to address it on future shows. Again, that's DadsDivorce.com. Mike, I appreciate you taking the time again and look forward to having you on the show.
Thank you very much. It's been a pleasure.
Take care. Thanks.
All right, bye-bye.